The second question is write short notes on. The first short note is of legal development through codification. Legal development through codification, a detailed note introduction. Legal development refers to the evolution and systematic growth of laws and legal systems in response to societal needs. Codification is a significant method of legal development that involves the process of collecting, systematizing, and writing laws in a structured and accessible form, usually as a code or statute. Codification has played a critical role in shaping modern legal systems, ensuring clarity, consistency, and accessibility of laws. Meaning of codification: codification is a process of organizing and consolidating laws into a single written code or document. It involves bringing scattered statutes and customary laws into a unified body, eliminating contradictions and obsolete rules, presenting laws in a logically arranged and coherent manner. Historical background of codification: Ancient period. Code of Hammurabi, Babylon, 1754 BCE. One of the earliest known legal codes. Roman law. The Corpus Juris Civilis Justinian Code was a major codification that influenced European legal systems. Medieval period. Laws were mostly customary and orally transmitted. Codification was limited and mostly local or religious. Modern period. The Enlightenment era emphasized rationalism and legal reform. Napoleonic Code 1804, a landmark in codification that influenced civil law systems worldwide. Objectives of codification: uniformity ensures that same laws apply to all citizens. Certainty and predictability. Laws are clear and known in advance. Accessibility makes laws understandable and available to the public. Simplification removes redundant and conflicting laws. Legal reform updates and modernizes old legal principles. Advantages of codification: clarity and precision. Written codes eliminate ambiguity in legal interpretation. Legal certainty. Codified laws provide fixed legal standards for judges and citizens. Democratization of law makes laws accessible to non experts, promoting legal literacy. Consistency and uniformity prevents arbitrary decisions and unequal treatment. Efficiency in adjudication streamlines judicial process by providing a clear reference. Facilitates legal education. Students and practitioners can study a comprehensive set of rules. Disadvantages and criticism of codification: rigidity. Codified laws can be inflexible in addressing new or complex issues. Oversimplification may ignore the nuances of customary or case law. Obsolescence. Laws in code may become outdated unless regularly revised. Judicial discretion limited. Reduces the scope for judges to adapt laws to specific cases. Codification in different legal systems. Civil law system. Strong reliance on codified statutes. Example: France, Germany, Japan. Courts apply law strictly based on codes. Common law systems. Codification coexists with case law and judicial precedents. Example: UK, USA, India. India, though based on common law, has extensively codified laws. Example: IPC, CRPC. Examples of major legal codifications: Indian Penal Code, IPC 1860, codified criminal law in India. Civil Code of France, Napoleonic Code, basis for many civil law jurisdictions. German Civil Code, BGB, comprehensive private law codification. United States Code, USC, compilation of federal statutory laws. Codification and legal development. Codification contributes to legal development by bridging traditional laws with modern needs. enabling legal reform through structured review and revision, harmonizing national and international legal standards, serving as a foundation for future legal interpretations and judgments. Conclusion: codification has been a cornerstone in the evolution of modern legal systems. While it brings numerous benefits in terms of clarity, accessibility, and uniformity, it must be complemented by regular updates and judicial interpretation to remain responsive to changing societal needs. As societies grow more complex, codification remains a vital tool for ensuring that the law keeps pace with development while maintaining order and justice. Second short note is on judicial review as special dimension of judicial process. Judicial review. Introduction. Judicial review is a fundamental feature of constitutional democracies. It refers to the power of the judiciary to examine the constitutionality of legislative enactments, executive actions, and administrative decisions. As a special dimension of the judicial process, judicial review serves as a safeguard against arbitrary power and ensures that all laws and actions conform to the Constitution. It strengthens the doctrine of the rule of law, upholds separation of powers, and protects fundamental rights. Meaning and definition. Judicial review is the process by which courts assess courts assess whether a law or governmental action is in line with the Constitution. If it is found to be inconsistent or violative of constitutional provisions, the court has the authority to declare it null and void. Black's Law Dictionary defines judicial review as a court's power to review the actions of other branches or levels of government, especially the court's power to invalidate legislative and executive actions as unconstitutional. Origin and historical evolution. United States. The concept of judicial review was first established in the landmark case of Marbury v. Madison, 1803, by Chief Justice John Marshall. In India, though not explicitly mentioned, judicial review is an integral part of the Constitution through the Articles 13, 32, 131, 136, 226 and 227. Judicial review in India draws inspiration from the US model but has been adapted to suit the parliamentary system. Constitutional provisions in India. Article 13 declares that any law inconsistent with fundamental rights is void. Article 32 and 226 empower the Supreme Court and High Courts respectively to issue writs for the enforcement of fundamental rights. Article 131 Original jurisdiction of the Supreme Court in disputes between states and the centre. Article 136 Special leave to appeal. Article 245 to 255 Distribution of legislative powers. These provisions form the legal foundation for judicial review in India. Types of judicial review. Legislative review examines the constitutionality of laws passed by the legislature. Example: striking down a law that violates fundamental rights. Executive review examines the legality and constitutionality of executive actions or policies. Then, judicial review of administrative action ensures that administrative actions are not arbitrary, unfair, or unreasonable, linked to principles of natural justice. Scope and dimension of judicial review. First, protection of fundamental rights ensures that individual rights are not violated by state action. Second, preserving the basic structure. Established in Kesavananda Bharati v. State of Kerala 1973, Parliament cannot amend the Constitution in a way that alters its basic structure. Third, maintaining federalism. Prevents encroachment by the centre on state powers and vice versa. Fourth, controlling abuse of power. Ensures that all organs of government act within the scope of their authority. Fifth, judicial review of constitutional amendments. Even constitutional amendments can be struck down if they violate the basic structure doctrine. Landmark cases in India. Keswananda Bharati vs. State of Kerala 1973 introduced the basic structure doctrine. Golaknath vs. State of Punjab 1967 held that fundamental rights could not be amended. Minerva Mills vs. Union of India 1980 reaffirmed the supremacy of the Constitution. Indira Nehru Gandhi vs. Raj Naren 1975 struck down amendment curbing judicial power. I.R. Coelho vs. State of Tamil Nadu 2007 laws under the 9th schedule are subject to judicial review if they violate fundamental rights. Significance of judicial review. Checks and balances acts as a check on legislative and executive overreach. Supremacy of Constitution reinforces constitutional supremacy over all state organs. Guardian of the Constitution. The judiciary acts as the ultimate interpreter of the Constitution. Rule of law ensures that government actions are conducted according to the law. Protection of rights shields citizens from arbitrary and unconstitutional actions. Criticism and challenges. Judicial overreach. Courts are sometimes accused of intruding into legislative or executive domains. Delay and backlog. Excessive litigation can slow down the judicial process. Subjectivity. Judicial discretion in interpretation can sometimes lead to inconsistent decisions. Democratic legitimacy. Critics argue that unelected judges overturning laws passed by elected legislatures raises democratic concerns. Conclusion. Judicial review is a powerful instrument in the hands of the judiciary to uphold constitutional values and ensure justice. As a special dimension of the judicial process, it enables the courts to act as a custodians of constitution and protect the rights of the people. While it must be exercised with caution and restraint, judicial review remains indispensable for maintaining the balance of power and the democratic fabric of the state. Third short note is on equivalence theories as a means of justice. Equivalence theories in jurisprudence explore the idea that laws and morality are not separate or opposing forces but are interconnected and mutually reinforcing. These theories argue that justice is achieved when legal norms align with moral and ethical standards, and any deviation of law from morality may lead to injustice. This perspective has been influential in both natural law theory and in modern human rights jurisprudence, where the validity of a law is judged based on its moral content. Meaning of equivalence theories. Equivalence theories are based on the premise that what is morally wrong cannot be legally right and vice versa. They reject the strict separation between law and morality that legal positivism maintains, especially as proposed by thinkers like John Austin and H.L.A. Hart. Instead, they assert that law must inherently contain a moral dimension to be valid or just. Philosophical foundations of equivalence theories. Natural law theory, the oldest and most prominent equivalence theory, promoted by thinkers such as St. Thomas Aquinas, Cicero, and later Lon L. Fuller, believes that law derives its legitimacy from moral values, reason, or divine origin. According to Aquinas, an unjust law is no law at all. Lon L. Fuller, the inner morality of law, argued for a procedural morality of law, listed 8 principles: clarity, consistency, prospectivity, etc., as necessary for a legal system to be morally valid. Believed law cannot be effective or just unless it conforms to moral standards. Ronald Dworkin criticized legal positivism, advocated a theory where law includes principles of justice, fairness, and procedural due process. Argued that judges should interpret the law in the best moral light. Equivalence theories and the concept of justice. How equivalence theories serve as a means of justice. Legal principle: law must be fair, law must be reasoned. Moral principle: moral equality, ethical rationality, justice outcome, equal treatment of citizens, avoids arbitrary power. Legal principle: law must be predictable, law must protect rights. Moral principle: moral trust, moral dignity. Justice outcome: ensures security and stability, preserves human worth and liberty. Thus, when laws embody moral values, they are more likely to be just and lead to social harmony and legitimacy and fairness. Application of equivalence theories in legal systems. Constitutional jurisprudence. Courts interpret the Constitution as not just as a legal text but also as a moral document. Example: in Justice K.S. Puttaswamy versus Union of India 2017, the Supreme Court linked privacy to human dignity, a moral value, thereby reinforcing the laws through morality. International human rights law. Rooted in equivalence theory, rights such as liberty, equality, and dignity are considered universally moral, and laws inconsistent with them are condemned. Natural justice principles. Nemo judex in causa sua. No one should be a judge in his own case. Odi alteram partem. Here the other side. These principles are moral norms that have become legal rules, ensuring procedural fairness. Criticisms of equivalence theories. Subjectivity of morality. What is moral to one person or culture may be immoral to another, leads to uncertainty in law. Difficulty in codification. Moral standards are not always precisely definable or codifiable in legal language. Third, tension with legal positivism. Legal positivists argue that law must be clearly separated from morality to ensure clarity and enforceability. Conclusion: equivalence theories provide a normative and philosophical foundation for underlying justice as a union of law and morality. They emphasize that laws must not merely be legally valid but also morally acceptable to be just. This approach promotes the protection of fundamental rights, ethical governance, respect for human dignity, and judicial fairness. While not free from criticism, equivalence theories guide courts and lawmakers towards justice, particularly in constitutional interpretation and human rights adjudication, making them an essential part of modern legal thought. Independence of the judiciary is the fourth short note, which we will do in next lecture. Next in my YouTube video.